Judicial review is the power given to the courts to declare an act of any other governmental actor unconstitutional.
So the genius of Marshall sets the court on the course of allowing itself to interpret law and to negate law, to claim that acts of Congress or acts of the legislature or acts of any other governmental actor can be null and void if they violate the Constitution.
Well, we all agree, or most constitutional commentators agree, that Marbury against Madison did create the power of judicial review, or the court created the power of judicial review in the Marbury against Madison case. But we have a big disagreement to this very day about what the scope of that power is. Can the Supreme Court rule any statute to be unconstitutional? Can the Supreme Court override the contrary constitutional judgment of a president? Can the Supreme Court invalidate the acts of the United States government in the field of foreign affairs, or is it strictly limited to the domestic realm? So we have a range of questions on which people disagree, and part of that disagreement is a disagreement about just how broad the scope of judicial review established under Marbury against Madison actually is.
It's interesting to note that the Constitution does not specifically spell out the power granted the Supreme Court. Before Marbury, the judicial branch was weaker than the executive and legislative branches of government. Marbury leveled the playing field, giving the Supreme Court the power to invalidate any law that, in the court's opinion, violated the Constitution. The background of the case was this. William Marbury was among the many appointees John Adams had given judicial positions to on the eve of his leaving office. When Jefferson came into power, he ordered the Secretary of State, James Madison, not to grant Marbury his appointment. Marbury, in turn, filed suit asking the Supreme Court to issue a court order requiring Madison to deliver his commission.
It was Jefferson who refused to deliver these commissions. And Marshall argued that he was obliged by statute law in the performance, or his Secretary of State, Madison, but back of Madison was Jefferson, that Madison was obliged by federal statute. He had no discretion. This was law. He had to deliver the commissions. Not to deliver them would be a violation of the law. What Marshall does in the middle of his opinion is give the President of the United States a lecture on the rule of law. It was pretty audacious. I mean, it was tremendously gutsy, controversial thing to do, as you might very well imagine.
Marbury versus Madison is the case in which the court breathes life into the institution of the judiciary, and John Marshall finds a clever way to tell Madison that he's wrong and makes him do nothing about it, which is the genius of John Marshall.
Marshall's decision established the Supreme Court's power of judicial review and recognized the Supreme Court as the ultimate interpreter of the Constitution. Any law written by the legislature and any order issued by the executive branch that conflicted with the Constitution would be deemed null and void.
The mentions of the judiciary in the Constitution are rather brief. Article 3 is of the three major articles that create the institutions of government, is by far the shortest. It is vague. Federalist 78, which points to the court and its role, is the most clear of all the Federalist Papers about the judicial branch. But still the role of the judiciary initially is not clear, and it's Marshall in his 34 years as Chief Justice who puts his stamp and shapes the judicial branch. There's a wonderful quote from Marbury versus Madison in which Marshall says, "It is emphatically the province and duty of the judicial department to say what the law is." And it's the court who sees their role as defining and interpreting the Constitution and what law means.